I used to, I used
They're
to
in your
actually, well, they were in my possession, but I was not like intending on taking because I didn't know that it was honestly like there. That's why. So,
Court does call the case of the people versus Sue Zai.
Assistant Prosecuting Attorney Morgan Rose on behalf of Siegel.
Edward Drooks on behalf of the defendant.
Signed in advice or rights form or
There should be one in the file. If not, then I'll have her sign it. We don't need one.
one signed. I don't have one. I have her sworn, please.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
So bizarre.
Ma'am, it is this court's understanding that you're going to be pleading. Court's understanding of the agreement is that the defendant will be pleading guilty to two charges. The stated count two, that being the charge of retail fraud in the third degree, the 92-day misdemeanor, as well as an added count three of analogs, the 1-year offense. Upon a successful plea, count one would be dismissed. Count three, there is no objection to 7411 and no objection to a prosecutor's deferred on count two. That's the court's full understanding of the agreement. Is that correct, counsel?
That is correct. In exchange, count one would be.
That's our
I think you
understanding.
said that, but okay. You're welcome. Hey, ma'am, you understand that you're pleading guilty to two misdemeanors?
Yes, sir.
All right. The first misdemeanor is that of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? Count three, use of analogs, also a misdemeanor, is punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
And to the charge of retail fraud, third degree, how do you plead?
So,
To the charge of use of analogs, how do you plead? Now, you understand that by pleading guilty, you will not have a trial of any kind. You signed an advice of rights form today, is that correct? Yes? Any questions regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes, sir.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
Well, I'm already on a drug test. It's been 8 weeks already.
Right, but are you under
Yeah,
the
no.
jurisdiction of any other court?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to
No.
plead? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of these offenses? On the date of October 15, 2023, at the location of 7000 East Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan, what'd you do at the Walmart that makes you think that you're guilty?
I changed some item price tags.
Okay, so you switch price tags on certain items in the store and you put a lesser price on
Yes, sir.
the items and then you tried to pay that lesser price and walk out? All right. Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you? And this property that you switched tags on, that was property that was offered for sale by Walmart? All right. And on that date, had you also had in your possession amphetamines?
Yes, sir.
Did you have a valid prescription for those amphetamines?
No, not at that time.
Not at that time. All right. And did you use those?
No, sir.
Were you intending on using them?
Well, I have had it and it was there for a long time. I didn't even know that it was even there. That's honestly, I have not. Well, I used to actually. Well, they were in my possession, but I was not like intending on taking because I didn't know that it was honestly like there. That's why. So,
Court does call the case, People versus Mary Barney.
Good morning, Your Honor. Chris Ito, appearing on behalf of with Mary Barney, who's standing to my right.
Good morning.
Your Honor, the PCT, my client wishes to set this matter for a preliminary exam. And if there's,
All discovery is complete.
Yes.
yes, sure.
You were going to say something.
And if I'd like to, when appropriate, address the condition of the bond.
People would have their witnesses available July 2nd.
We'll do our best.
Preliminary examination in person will be set July 2nd, 2024, 9 a.m. That is before
Judge Washington.
Judge Washington. Yes, Esteban.
Your Honor, my client is serving currently a less than a year sentence from Judge Barr right now. And the complaining witness for the felony portion of this current case that she's hearing today, the complaining witness is the father of her 3 children, and she is currently pregnant and is due in October. I understand that I've substituted the no contact with Mr. Greenlee, who is the complaining witness on the felony. He is the father of the children and the child to be born in October. My client, and I believe Mr. Greenlee, is in agreement if the court would be willing to waive or to amend the bond condition to allow her to have contact with him, phone calls from the jail.
Your Honor, it has been communicated to our office that the woman would like contact. I am really opposed to that in this case. This is a case where I do believe Ms. Barney's phone privileges have been revoked because she contacted the victim 74 times in violation of the no contact order through jail calls. So I don't think that any modification of bond conditions are appropriate in this case.
Your Honor, if I could address that. So if they're monitoring all her calls. So if there's an issue with her calls, then certainly they have things they can do. Otherwise, given the background of the family background, the fact that she's due in a few months, I'm not sure what they're expecting from that. Certainly,
How long is she in custody?
How long has she been in custody?
Well, no, I guess.
The full year on the child abuse case before Judge Barr.
So I think that was in April.
That's correct.
May
15.
15th. So there is a pending motion up in front of Judge Barr to change that. Given she was denied access to the mental health court. So that is being addressed with Judge Barr right now in a couple of weeks or next week. But having contact with there's no way for her to check on her children. There's no way for her to talk to about her health. There's all these issues going on that communication.
What are the prohibitions on the child abuse case? So, I mean, I know she's under sentence, but.
She has been sentenced to jail. Judge Barr was considering modifying the jail sentence if she were to be accepted to mental health treatment court, from which she has been rejected.
To answer your question, it's not about contacting the children. I don't think there's a no contact with the children. Or him. There's not a no contact in any of the cases. So that's why we're wondering why she's being.
Is that correct?
I'm not certain. If you give me a moment, Your Honor, I can check in the notes.
Well, they're checking that. Typically, I would need to hear directly from the alleged victim in this case before I would change anything.
He's here, Your Honor, if you want to speak to him. My understanding of the no contact order or that issue, Your Honor, was no non-consensual contact with Mr. Greenlee.
Your Honor, my understanding of the prohibitions in the child abuse case, according to our notes, is that Ms. Barney was allowed to have contact through CPS, which was to be facilitated by the victim in this felony case. With the no contact order in place in this felony case, any facilitation of visitation through CPS facilitated by the victim here is not occurring.
So before she went into custody, she got from the family court, she got an order for completely unsupervised visitation with all her children. That's a court order from the circuit court. And the issue is more of the contact with Mr. Greenlee and having contact with him so that she can find out how everybody's doing. Education, medical decisions. He wants to check in on her. He is present in the courtroom if the court would like to address with him. But this is, I'm at a loss to why these two can't talk to each other. Certainly the prosecutor has the right to look at all their phone calls and see if there's anything inappropriate said while the case is existing. But beyond that, I don't understand why they can't talk to each other.
I'll indicate no non-consensual contact. I don't know that necessarily addresses, and I'll let Judge Washington address whether or not her phone privileges at the jail will be reinstated. But I'll order no non-consensual contact.
Thank you.
Case People versus Michael Jones Fuller.
Good morning, Your Honor. Marcia Creech on behalf of Mr. Jones Fuller, who is, can you please state your name, sir?
Michael Jones Fuller.
Good morning, Your Honor. Your Honor, we'll be requesting a preliminary exam in this matter, Your Honor.
All discovery is complete.
Yes, Your Honor, I've received the complaint, I've received body cam video and the police report, Your Honor.
I do have one thing about bond I'd like to bring.
Before I said it or after?
I'm sorry, whenever the court.
Okay, well, I'll do it this way. Would the people's witnesses be available the second?
I will try my best, Your Honor.
Preliminary examination in person, July 2nd, 2024, 9 a.m. That is before Judge Harry. Yes, that's the bond.
When he was arraigned on June 13th, 2020, he called his friend, then after he was told not to contact the victim, he called his friend to ask and gave the friend the victim's phone number and asked the friend to have the victim bond him out or to give him money to bond him out. So I'm concerned about the fact that he was ordered by the court not to contact the victim, and then he went ahead and did that prior to being bonded out on the 13th jail call. We had originally asked for a $250,000 bond in this case, and he was given only a $25,000 bond. So I am concerned about that.
Mr. Creature.
Madam Prosecutor said she sent me, and I'm sure she did, but I've not received the audio of the jail call, so I cannot respond what's in it, what's not in it. What I can tell the court is that
There were calls made to the victim.
I can't represent that.
Correctly?
I haven't heard them. I
guess I want to make sure I'm hearing what I think I'm hearing.
There were calls made to third party, telling the third party to contact the victim and giving the victim phone number to the third party. That was the same phone number in the police report.
Got it. Okay. Go ahead.
All right, so I cannot speak to the phone call because I've not heard the recording of it. What I can tell you is that I have yelled at my client, admonished my client, if that did happen, he's not to have any contact with the victim. He's not to contact or have a third party contact her in any way or fashion.
Well, why did he do that in the first place?
I don't know if he did or he didn't. It's the
Mr.
first I've heard
Allen.
of it.
Go ahead. What?
He explained to me that he did make a call to his friend Ali to have funds released so he could be bonded out. That's what my client tells me. I don't have the jail
So
costs.
he's saying that he didn't have any contact with or direct anybody to have contact with the victim in this case? Is that what you're representing to the court?
If I could have a moment, Your Honor. Your Honor, after conversations with my client, he states to me that he did ask his friend to contact the complaining witness in order to release funds to have him bonded out, Your Honor. He understands that he shouldn't have done that. I've yelled at him about that. I've explained to him that he cannot have any contact with the victim. He did not, on that jail call, from listening to Miss Blanche's details, tell her not to show up, tell her not to cooperate. So I would ask that he be allowed to remain out on bond, Your Honor. I can't hear you. Sure. And he wanted me to continue to say that he is fully employed, has a job waiting for
I
him.
understand that, but he's given certain conditions regarding his bond and just willfully violates. Defendant's bond is modified, defendant's remanded, defendant's bond will be set in the amount of $100,000 cash share.
Thank you, Your Honor.
Court does call the case, People versus Hazel Jacobs.
After Mr. Jacobs, who approaches. Mr. Jacobs, can you please state your name for the record?
Thank you.
Thank you. Your Honor, with regard to the matter that's set before the court today, would we asking to set for an exam?
Discovery is complete.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the second. Preliminary examination in this matter will be set in person July 2nd, 2024, 9 a.m. That is before Judge Washington. Bond continues.
Well, Your Honor, it appears we
Go
are,
ahead. You want to argue bond?
I do, Your Honor,
Go
and
for it.
it appears we are here on a bond violation as well. I don't know if that's what the docket said is. And the only information, Your Honor, I have with regard to the bond violation was that he was taken into custody on an alleged no contact violation that occurred at his house, where my client advises that the complaining witness showed up. He asked to leave. The police got involved. He was taken into custody as a result. I don't know exactly how that all came about. I believe that some yelling occurred. The police were called. He was taken into custody as a result. Your Honor, he does reside in a home with where he lives without the complaining witness. He is asking for some consideration there. He understands that he's not to have any contact as far as I'm concerned. And as far as I know, he did not intend to have contact that day. She came over. It was inadvertent in that he now knows that he cannot have the contact. He does have a 3-year-old daughter. He shares custody with the child's
Did you
mother.
request a hearing on that?
Because
I had already, I think, addressed this.
I thought
and
you
he
may have.
increased his bond at the last hearing.
That was our impression too. I don't have any additional information if there was additional violations or anything alleged. I don't see anything in our file from community corrections indicating that there were additional violations. I was under the impression that this was addressed when Ms. Hughes handled it.
I thought it may have been too, Your Honor. I just saw that it was set for a bond violation hearing today as well, and I did want to put up a bond argument on behalf of my client. I would ask. He has been in jail for the last 9 days, Your Honor. I would ask for home confinement if the court would consider that. He knows he can't have contact with her. He didn't intend to that day, and he, for all intents and purposes, wants to keep that contact from happening.
Okay, having heard nothing different from the last time, there's nothing that's going to change the court's position in the bond in this case.
Okay.
Well, this motion for bond reduction is denied. Bond will continue. Thank you.
Oh, Your Honor. Finally, I just real quickly, he is on a tether. I don't know that since he's in custody that's necessary. If we could at least have that taken off or some consideration for that to be taken off of him.
We'll leave that to the jail.
The jail.
He's now.
Your Honor, the jail is leaving that to the court, is what I've been informed of. The jail won't do anything without an order from the court.
I don't know. I don't see that he has any other cases pending, so.
I don't know that. I don't know. Is this the only case that
This
he's
is-
got a tether on?
This is the only case that he has a tether on.
Well, they can take the tether off. They
Okay.
want their tether back. I don't care. He's not going anywhere.
Thank you.
If he leaves, he has to have the tether put
Understood.
back on. He understands that.
Thank you.
Calls case, People versus Marion Smith.
Your children depend on the actual people.
And it's just a public matter. Let me stop on behalf of Ms. Smith. Smith, state your name for the record.
Marion Smith.
I have a plea form in front of me. Is that what we're doing?
Yes, Your Honor.
All right. Plea form indicates that Ms. Smith will be pleading guilty to count 9. Larceny by false pretenses, 200 to 1,000, the 1-year offense. Upon her successful plea to that charge, counts 1 through 8 would be dismissed. And there is an agreement that it is okay to seek a prosecutor's deferred on the added count 9. That's the court's full understanding of the agreement.
That's correct.
Is that correct, Henry?
Yes, Your Honor.
All right, very good. May I have her sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Marion Smith.
All right, Ms. Smith, it is this court's understanding that you are going to be pleading guilty to added count 9 of larceny by false pretenses, 200 to 1,000. It's indicated that is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
I do.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights that are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I'm not.
You all right?
I am, but I'm okay. I really am.
Huh?
Okay.
All right, just take a deep breath. I would say it's like too hot out there to be crying. All right. All right.
Okay.
All right. Are you on? Here you go. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
of your own free will
Yes.
and because you believe that you're guilty of this offense, ma'am?
I am.
The date of February 2nd, 2023, at the location of 4001 South State Street, City of Ann Arbor, or Pittsfield Township, Washington County, State of Michigan. What do you do that makes you think that you're guilty of this offense, ma'am?
I used a card that wasn't mine.
Okay, you used a credit card,
Yes.
and let's break that down a little bit. You took that credit card into where?
Myers.
Into Myers. And in going into Myers, you tried to purchase some items?
Yes.
All right. And that credit card was not only yours, but also you didn't have any authority to use that card, did you?
I did not.
All right. And were you able, or did you attempt to try to purchase items?
Yes.
All right. Was the amount that you purchased in excess of $200?
That I'm not sure about the
No.
oh, well, yes, as far as the amount, I don't know.
The total amount.
Oh, yeah.
Right. Was it more than $200?
Oh, it was over, not gonna say for sure, yes.
Okay, but it was over that?
Yes.
Okay, and you're not disputing that, I guess.
No, not at
Put it
all.
that way. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied. Your Honor.
Court will accept the defendant's plea of guilty to count 9. Counts 1 through 8 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
July 24th at 9 a.m.
July 24th, 2024, 9 a.m. That is before me. I'm going to put on here. Prosecutors deferred on this one, so they'll probation examine that, okay?
Thank you, Your Honor.
All right. Bond, you all right?
Thank you.
You're welcome.
Make peace. I'll be okay.
What did you say?
I said, I'm gonna make peace. I'll be
Yes.
Okay.
Yes, we do.
So thank you.
Bond will continue. When you leave out, the probation department is right down the hallway on your left.
Okay.
Stop in there with them and just tell them that you were just here before me.
Okay.
Okay? All right. You
Have a
take
good day.
You too. Versus Kyle Rainey.
Assistant Prosecuting Attorney Morgan Barossa on behalf of the people.
I apologize, Ms. Barroso. Joy Gaines, Senior Assistant Public Defender representing this. Your Honor, I called Mr. Rainey's name out in the courtroom and in the hallway with no response. I have no explanation for his whereabouts at this time.
Kyle Rainey. No response. Bench warrant will issue. For defendant's failure to appear, bond set in the amount of 10,000 cash surety. That warrant will issue immediately.
Thank you.
Court calls case, People versus Jovan Smith.
We're ready in that matter. I'm Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Smith, who is approaching the podium.
Andrew Children is here now. People are-
Go ahead and state your name for the record.
Jovan Smith.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We believe that there's a lot more discovery that's going to be coming out of this case. We're going to ask for an adjournment. We're not certain when the discovery will be completed. So we'll probably need at least a couple of weeks. At least a couple of weeks.
Will that be enough time, you think? I mean,
Yeah.
Good, okay. Thank you, Your Honor. And there was,
Pardon?
I'll address it after.
Probable cause conference, July 18th, 2024, 9 a.m. or as your invite indicates.
Thank you. Your Honor, my client has a tether on his leg. He has a prescription, needs to have an MRI.
Okay, yeah, you do. Go ahead.
Have an MRI performed,
Ah,
and here's the prescription for it. The tether will interfere with that.
yeah,
Just
it
needs
would.
permission to have it taken off just so that he can complete the
When
MRI.
is that scheduled?
Well, I haven't scheduled the appointment yet, but I have a note from the doctor. He just told me whenever I can get this settled, then I can get the MRI.
Okay. Well, just so that we don't. Can you, if you don't have it off, but there's an order that allows you to have it off, can you get it scheduled? I mean, can you call your doctor, get it scheduled? And then what I would prefer happen is you call your doctor, get it scheduled, let attorneys know what date it's scheduled. And then I would be more than happy. I'll execute an order that just indicates that he can have it removed for that procedure that day. And then then you would need to have it put back on.
Okay.
Okay. So get it scheduled and then I'll do that. That's not a problem.
All right. We'll prepare an order once he gives us the date.
Once you get the date.
Okay. Thank you, Your Honor.
Okay, not a problem. Bond continue.
Thank you, Your Honor.
All right. Thank you, sir. Calls case People versus Jacob Patton.
Prosecuting attorney Morgan Barroso, on behalf of the people.
Good afternoon. Assistant Public Defender Lauren Perny on behalf of Mr. Patton, who should be on Zoom. Mr. Patton, can you unmute and state your name for the record, please?
Yep, it's Jacob Patton.
Thank you.
All right. What are we doing?
Your Honor, you should have a plea form.
I do. Is that what we're doing today?
Yes, sir.
Plea form indicates that the defendant would be pleading guilty to refusal to obey a traffic order, the 90-day offense. Upon his successful plea to that charge, count one would be dismissed. That is the court's full understanding of the.
As is mine.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Jacob Patton.
All right, Mr. Patton, it's this court's understanding that you're going to be pleading guilty to the charge of refusal to obey a traffic order. That's a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs. Do you understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Understood.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
June 26, 2021, at the location of Main Street near Barker Road in Northfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
All right. And what happened with reference to a police officer? Yes, sir.
I was given orders by a police officer, and I failed to comply with his order.
And what order specifically do you recall? Was it a traffic order to pull over or something along those lines?
Yes, sir.
Okay. And you're not disputing the right of the officer or that the officer was acting lawfully and giving you that order, are you?
No.
All right. And so have I complied with the court rule? Would it be proper to accept this defendant's plea?
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
August 20th at 1 p.m. before Judge Fresh Hour.
August 20th, 2024. What time?
1 p.m.
1 p.m. before Judge Fresh Hour. Bond in this case will continue.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case People versus Delonte Napier.
Jessica Blanche, Parent People.
Go.
I just colleague offender Natalie Pate with and on behalf of Mr. Napier, who is approaching. Please state your name for the record, sir.
Delonte Marion Napier.
Renner, as to the PCC, we would wish to set this matter for exam. We believe all discovery is complete, and when appropriate, I would also like to address bond briefly.
Would people have the witnesses available the second?
Yes, sir.
Preliminary examination in this matter will be set in person, July 2nd, 2024, 9 a.m. before Judge Perry as to bond.
Thank you, Your Honor. It is my understanding that bond in this matter is currently set at $1,000, 10% cash surety bond. We are respectfully requesting the court to consider setting a PR bond in this matter. My client would stay at the Stafford Court Apartments with his brother. He clearly understands the no contact and no go-to conditions of bond. To my understanding, he has not had contact with the complaining witness in this matter since his arraignment. And he came into custody on this warrant. He did not know that a warrant had issued for the case, but he came into custody at a traffic stop at Burger King. No new charges stemmed from that. And he was taken into custody without incident, to my understanding. He is employed as a canvasser and registered voters. It is his understanding that he could return to work after he is released. We are asking that the court consider setting a PR bond in this matter.
Judge, I believe it was set a low cash bond because he has a pending 14B restriction of property DD that he was on probation for. So I don't know what the status is. I was trying to look up that case, see what the status is on that, but I think he may be revoked or remanded on that case.
That is correct, Your Honor. At arraignment bond was revoked in that matter, and he is being seen today by, I believe, Judge Washington.
But right now it stands at revoked.
Yes, but his court
So
is.
why would I change this at this point?
Because he is under the understanding that he believes it changed.
Motion for bond reduction is denied.
Thank you, Your Honor.
Calls the case of People versus Franklin Melton.
Calling on behalf of Mr. Melton, who approaches. Melton, would you state your name for the record?
Franklin Joseph Melton.
And Your Honor, I have a tentative offer worked out with the prosecutor on this matter, Ms. Tanha. And I just wanted to see about getting one final adjournment in so we could work out the details of that.
This is the only thing he's held on.
This is the only thing he's held on, Your Honor, and I do have an answer for the court with regard to bond. A couple weeks ago, the court wanted me to make sure with the prosecutor, as well as the court itself, that Mr. Franklin had a place to, or Mr. Melton had a place to go in terms of my getting into contact with CMH. He does. I was able to get a hold of his CMH worker. He is set up for ACT services. We would be asking for release on home confinement. I think the court was concerned last time that he didn't necessarily have a place to go, and I've been able to work that out.
Yes, but did you talk to the prosecutor about that?
I did.
Are they in agreement?
I'm in agreement if there is a specific address, which my understanding is that there is a specific address that has been provided by CMH, that this is housing through them. I haven't seen that email specifically, but
All right, look, if that was, I'm sorry, to interrupt. If that was the issue, just prepare an order for my signature that both
Okay.
parties can agree upon, and I'm not gonna have an issue.
Okay, thank you, Your Honor. I will have that to the court
I'll
today.
adjourn the probable cause July 2nd, 2024, 9 a.m. Bond continue.
Thank you.
Calls case People versus Samuel Klosky.
On behalf of Klosky, Mr. Klosky, could you state your name for the record?
Samuel Bruce Klosky.
Thank you, sir.
He's waiving examination.
That's correct, Your Honor.
Sir, you signed this examination waiver?
Yeah.
You understand the preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed.
I understand.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendants bound over on both counts. Thank you, Your Honor.
Your Honor, we acknowledge receipt of the information, waive any reading on the record, and would ask that Mr. Klosky be permitted to stand mute to the offense.
Defendant having waived from a reading, standing mute, court will enter a not guilty plea. Pretrial will be set for July 9, 2024, 1:30.
That's good. So it'll be before your other court date.
Bond continued. Thank you. Case People versus Jeffrey Long.
Deputy Chief Public Defender appearing with and on behalf of Mr. Long. Mr. Long, state your name for the record.
Jeffrey Long.
Your Honor, today is the date and time set for the probable cause conference. I have heard from the director of AIM. They need at least 2 more weeks to be able to complete an assessment. So we'd ask for an adjournment.
At least 2 weeks, or are they gonna have, well, you're looking for a report to come out of that.
Exactly.
Correct. So is it 2 weeks to complete the assessment and report, or
That the impression I have is 2 weeks to do both. Yes.
to do both? Any objection from the?
I think 2 weeks was July 4th. so-
All right. That's what we're talking about. Yeah, so 3 weeks would probably.
I was gonna set it July 4th, make Richard Brown come in. That's what. So what I will do is probable cause conference, July 11th, 2024, 9 a.m. Bond continued. That's denied.
That date is July 11th. Then.
11.
Thank you.
Sure. Court does call the case People versus Devin Miller.
Good morning, Your Honor. Ashley Lonnie for the people.
And my name is Craig Tank, and I appear on behalf of Mr. Miller.
Your name, sir?
Devin Miller.
Thank you. Go ahead. What are we doing?
Your Honor, today is an adjourned probable cause conference in this matter. Defense counsel's been in contact with myself and Mr. Emmons this morning regarding this case. I think he's going to be requesting another adjournment. The people are not opposed.
That is correct, Your Honor. We wish to have another adjournment if we may, please.
All right. How much time did you need, counsel?
I would think 2 weeks would make it quite safe.
All right. Why don't I can do July 2nd. He's in custody, so I can do July 2nd, or I can do the 11th.
The second would be great, Judge, and thank you.
All right. Probable cause conference, July 2nd, 2024, 9 a.m. Bond continued.
Thank you very much.
Thank you. Calls case of the People versus Lisa Ratliff.
Assistant Public Defender Natalie Pate for Ms. Ratliff, who is approaching.
Your name, ma'am?
Lisa Ratliff.
All right, what are we doing?
Thank you, Your Honor. We are respectfully requesting, if possible, a 1-week adjournment in this matter. I did hear from the people yesterday that there would be no misdemeanor offer in this matter. Ms. Ratliff does have another court date on a misdemeanor that she is also being held on next Wednesday. To that end, we'd respectfully request a 1-week adjournment if possible.
June 27th, 2024, 9 a.m. Bond continued.